Hi, welcome to Illinois Law, presented by the Illinois State Bar Association. Today we're putting on a program entitled How to Determine Maintenance Payments in a Marital Dissolution Matter. I have the privilege of having with me today Julie Neubauer from Ehrenberg, Goldgen, Davis, and Garmissa, a law firm here in Chicago. And Julie is a member of the Women in the Law Committee with the Illinois State Bar, as well as a member of the ISBA Assembly. Welcome, Julie.
Thank you for having me.
It's a pleasure. Now, is there a statutory guideline, meaning a regulation, that sets a percentage guideline in determining maintenance payments in a marital dispute matter?
Unfortunately, no. Or from some people's perspective, fortunately, no.
Okay.
Setting maintenance, which is also known as alimony or spousal support in a dissolution of marriage action, is discretionary. And what that means is if the parties can't agree on that issue, if it's brought before the court, that the judge will make the decision as to whether maintenance is warranted, and if so, how much and for how long.
Is there usually a percentage informally that judges use? It just varies case to case, perhaps?
Some people will say that it varies by county. Others will say by judge. Some judges, I think, do have formulas in their head based on their experience with dissolutions over time. They get an idea of the factors that they weigh, and they determine maintenance within their experience as well as the context of the statutory guidelines under Section 504 of the statute that governs marriage and dissolution of marriage in Illinois.
And in your experience, what is this percentage that they kind of come up with themselves based on the statutory guidelines? You can't pinpoint. Okay, all right, just trying to pin you down there. Who's eligible for maintenance?
Well, the way that maintenance is determined, it becomes an issue only when you have a marriage that involves an inequality in the parties' individual abilities to become self-sufficient apart from one another. So, generally speaking, maintenance is awarded to the spouse who was not the income earner during the marriage. And various different factors are brought into play when determining how much, how long, and whether maintenance is warranted at all.
What about a situation where both marital partners owned a marital business together and one left the business and one remained, and they both earned income during the length of the marriage? Would that be a situation that the one who left the business and doesn't have employment yet or another opportunity of earning money would be eligible perhaps for maintenance in that situation?
That would be a common scenario where maintenance would most likely be warranted. But of course, there are many factors that come into play. Generally speaking, the way that maintenance is determined is by analyzing the requester of maintenance needs, the potential payor of maintenance ability to pay, under the umbrella of what the lifestyle was during the marriage. So going forward, because in a situation like you just described, only one party is going to remain involved with and earning income from the business that was once the income source for the entire family, that would continue to be most likely the income source for both parties through the vehicle of maintenance.
Okay. And are these maintenance orders, are they temporary? Are they permanent? What type of order is usually issued?
Well, the statute allows for several different kinds of maintenance. You can have what's called rehabilitative maintenance, which is an opportunity for the dependent spouse to rebuild and rehabilitate themselves as a self-sufficient income earner. So it would be applicable in a situation where you have someone who could go to school or finish school that they've just started in order to embark on a new career, which would allow them to earn income to become self-sufficient and maintain a lifestyle that they've become accustomed to during their marriage. Now that can be done on a set time frame where it ends and terminates at a specific date, or it can be considered reviewable so that the court retains jurisdiction over the issue and the parties can bring it back before the court to determine whether it should end or continue and whether it should increase or decrease in amount. Now, there's also the option of permanent maintenance. Permanent maintenance applies in situations where usually you have a long-term marriage and a very disparate income deficiency between the parties. One party was the breadwinner for 20, 25, 30 years, and the other party was the homemaker, stay at home with the children, and did not have an income earning history. Or sometimes you'll be dealing with a situation where one party is ill or disabled, and those are often scenarios where you'll see permanent maintenance. The last option for maintenance is something called maintenance in gross. And that's a lump sum of maintenance, a fixed amount that is non-modifiable. And it becomes, you can pay over time, but it is usually in the form of an offset from property. So somebody would get essentially a disproportionate share of the marital estate, plus maintenance in gross, which is a lump sum that they are vested to receive the entire amount, whether it's paid over time or right at the end of the marriage.
Now, how does maintenance interplay with child support? Because in a situation where we have higher income earners during a marriage, certainly there's more funding to pay both child support and spousal maintenance. But in a situation where we may have an average wage earner, let's say $50,000 for a family of four, 2 children, 2 adults, is that a common scenario where you're going to have child support for the children and maintenance to the spouse? Doesn't the court look at, how much money is actually there, if it's affordable? I mean, even though the other spouse may not have worked, is it a situation that maintenance still would be applicable?
This is why maintenance is discretionary and why there is no set percentage or formula that judges are required to use.
Okay.
Because each situation is different.
Okay.
When you have children involved, minor children, that is a statutory percentage of income allocation or allotment for child support. When you have one person who is determined to be the residential custodial parent, the other parent most likely, sometimes there's scenarios where it doesn't happen, but most likely is going to be paying child support on a statutory percentage basis. For one child is 20%, 2 children 28%, and so on. Now, when you are dealing with a situation where it could be warranting both maintenance and child support, you're usually looking at a situation where you have a very high income earner and a person who is disabled in a way from earning their own independent income. Most likely that disability, and unfortunately that's the word that is often referred to, is the fact that they are in a position to have to care for the children. So they are not able to balance it all, work full-time at a level that would allow them to be self-sufficient and raise the children.
Well, Julie, anything else you'd like our viewers to know?
Just know that one of the best ways to protect yourself is to seek good advice from a lawyer if you're embarking on the decision to divorce from your spouse, and to take the advice of your lawyer, who can provide a more detailed and personally catered approach to whether maintenance is right for you.
Thank you so much, Julie.
Thank you.
And thank you, viewers, for tuning in.
Thanks.